its members of its community that are accused of violating its laws. So all of you are bringing special talents into this room that we want to recognize. And as just even a final goal, another one of our goals is to rope you all into doing even more work. So thank you for joining us on this journey. But there are some specific shout outs that I am tasked with. And so I will turn to those first. To the members of the legislature that are in our room and their staffs, welcome. We appreciate your continuing engagement with this issue. I am sure that there are people in this room who have an opinion about what your future legislative priorities should be. And so we thank you for coming here with an open mind and listening to what they have to say. To members of various nonprofit organizations, thank you for being here. We hope to help you with your work, even while we're asking you to help us with ours. To the students volunteering outside and also in this room to help volunteer, thank you. You are the future of this topic. And finally, the very most important group of people in this room are the formerly incarcerated and their families. We thank you for taking time out of your lives to come guide us and lend your expertise as we work together to reimagine a future in which incarceration is no longer a possibility, much less the default for various problems in our society. We are honored to have you with us. There are two people that need specific shout outs, and that is Norma Wassel over there and Casey Resende Abbott. Thank you. Yes. And Casey Resende Abbott, you might have missed. She is out there at the table, but I encourage you to look for her name tag and to meet her because she is amazing. She is a student here at Suffolk Law School, and if you got emails, if you saw flyers, it was because she created them. And one day, every single member of the Women in Incarceration Project will be writing her a letter of recommendation and advising you to hire her. So take the time now to get to know her. All right, why are we here and why now? First, I just want to acknowledge that we are speaking against a background in which the Department of Corrections has announced an intention to build a new women's prison. So while that is not the focus of today's discussion, it is very much present in the motivations that bring us here today and part of what is guiding us in our work. Our goal here at Suffolk with the Women and Incarceration Project is to urge all of us to think outside of the box and to radically reimagine what the future of this state will look like. And part of that work has been to look at the laws as they are currently written and to imagine all that could be accomplished even without legislative action. So for example, nowhere in the statutes of the state is there a definition of what a prison is. It's not in the statutes. So could we imagine a prison without locks, with open doors and open to the community? And as another example, we have mechanisms for early release that already exist, including clemency, parole, and medical parole. So we are here holding this conference now after the recent election to urge, but before a new change in administration actually comes in, to send a strong message to this new administration that you have to make this one of your priorities. You need to be creative and innovative in imagining a future that is fundamentally different from our current situation. And you can do that hopefully with legislative help, but also without it by using the mechanisms that already exist, but that currently are not being deployed to their most effective extent. We can no longer ignore the plight of the incarcerated and their families, and we need to address our fundamental failure as a state to treat them with respect and dignity. So more specifically, as I've already alluded to, we are here talking about those members of the incarcerated population who, under any reasonable interpretation of the terms parole, medical parole, or clemency, should be released. And we are demanding that the new administration take these terms and actually give them content and meaning and effectiveness within this state. For the past 3 decades, these concepts have been rendered an essential nullity. And we are calling on the new administration to actually give them content that will allow them to be a pathway for release that they were intended to be when they were developed. And as we're talking about these categories, I want to emphasize our focus here is on building the teams that can develop a strong case to help women obtain parole, clemency, and medical parole. But in the background of this conversation, keep in mind that there are decision makers within this state who ultimately control who receives clemency, parole, and medical parole. And those decision makers all reside within the executive. So further emphasizing the change in the executive and the impact that can make. And those individuals include the parole board, the Department of Corrections, and ultimately the governor herself, right? So that's just giving you a little bit of the background of why we're here and what our goals are for today. And then I'm going to turn it over to my colleague, Rebecca Stone, who's going to give us more information on the population that's currently being held at MCI Framingham and how a more robust interpretation of these terms might impact that population and further reduce it. Thank you, Rebecca.
We'll see. All right. I am the only person who made slides for today because I can't leave the classroom. Let me see. This one. Ta-da! Okay. We should be all set. All right, so thank you so much to Erin for our introductory remarks and for outlining the existing pathways to women's decarceration here in Massachusetts. I want to just take a few minutes to go over some of the data that we have about who currently makes up this portion of the DOC's population in custody. And it's important to understand this info to understand the pathways that are available to the existing folks there. I prepared this presentation in collaboration with my colleague, Susan Sored, who's worked extensively with system-involved women in Boston, including many visits herself to MCI Framingham. So I want to preface what I'm going to say with some general comments on data limitations. As a criminal justice scholar, I can tell you that criminal justice data are bad, right? We have an entire social science field built on pretty poor record keeping and data, and not a lot of data transparency. So there are real limitations to what we can do with the information that we have available. And that's true across the country and is a major barrier to meaningful reform. So I think one of the things that we need to push for, in addition to all of the other things that we're trying to do, is better data collection and transparency so that we can actually understand what's going on. But that said, we do have some data from the Department of Corrections dashboard, as well as from our own public records requests that we've made. And in some places, I do want to note what's not available. Importantly, I want to say that the available data do not allow us to distinguish the gender identity of folks who are currently incarcerated. So they're just classified by sex. While it kills me to say females, I really hate that term, that is the term that the DOC data use. So they talk about their population of females in custody. And as you can see, this would likely include folks who identify not just as women, but also trans men and other gender expansive folks who are in need of pathways to decarceration as well. But what I want to draw attention to here is that the state female custody population, as described by the DOC, has steeply declined since 2012, which of course indicates what we know, that incarceration is a policy choice, right, that we make, and that decarceration is possible, reducing this population is possible. It is such that now Massachusetts has one of, if not the lowest incarceration rates for women in the country, but that's still at least 180, and actually a little bit more, about 219 as of October this year, people who are removed from their communities and from their families and who need pathways out of prison. And that's why we need the effort of everyone in this room to get them out. This number would fluctuate from day to day. Of course, the DOC largely has snapshots available on the 1st of each month or their major report in January of each year. But among that number, it remains constant that roughly 75% of the population are people who have been criminally sentenced to incarceration, which means that pathways out for them are going to involve parole, medical parole, clemency, or post-conviction relief, as Erin described. That said, there does remain a significant number of people who are detained pre-trial. That's not our focus for today, but we also need pathways for those folks, right, around bail reform and just not holding people pre-trial. So there are other mechanisms through which we might reduce this population, but we did want to highlight the number. And then as of January 2022, the records show that there were 6 people at MCI Framingham who were held there as civil commitment, which is weird because in Massachusetts, women are not supposed to be at MCI Framingham under civil commitment. And this number is actually higher. The October snapshot says that there are 12 civil commitments. So we don't know more about those cases at the moment, but we do want to keep an eye on that number in case that is an upward trend. It's not clear from the data at the moment. It's certainly higher than in the past, but we are watching that. As I'm sure folks in this room are aware, the burden of incarceration disproportionately impacts women of color and thereby their families and their communities. So we know that Black or African American women in this state are represented in our incarcerated population at a rate more than double their proportion of our actual state population. So this is a racial justice and equity issue, of course. We don't have more extensive data on folks currently incarcerated at MCI Framingham, but from general criminal justice research on women and prison, we know that women are more likely to enter prison with histories of abuse in childhood and adulthood, as well as trauma from witnessing or experiencing violence, from the loss of loved ones over the course of their lives, and from other adverse lifetime experiences. They're also more likely to enter prison with high rates of asthma, arthritis, cancer, and other acute and chronic health conditions, which are then worsened by the substandard living conditions in prison. As a population, incarcerated women have diverse physical health needs that change over the course of their lifetime, which includes reproductive health care, and these needs are not adequately met in our prisons. Most incarcerated women are the mothers of minor children, and they were more likely than incarcerated men to have been the primary carers for children, as well as for other people in their families and in their communities. So when we remove them, we are also removing pillars from the lives of those folks as well, and leaving people without care. We also know that women are more likely to be incarcerated further away from their communities, which makes visiting more expensive and more difficult. Even before the pandemic, women received only half the number of visits that men received while they were in DOC custody, which means that they're not getting that visitation time with their children and families. In part because of histories of trauma, incarcerated women are more likely to experience mental health challenges. So at MCI Framingham, the DOC data indicate that 83% of the population has open mental health cases, 76% are diagnosed with serious mental illness, and 69% are on psychotropic medication. But I do want to contextualize these statistics, right? Because people stigmatize mental health, and also this is not a complete picture of what's going on. So these statistics can't be interpreted alone. Importantly, they do not account for the impact of incarceration on people's mental health, which we know has a serious impact. So the experience of being incarcerated, the prison environment, separation from family, and other related factors are likely influencing these mental health numbers. The DOC also does not publish data on physical health challenges, which may contextualize mental health. For example, the impact of living with chronic health conditions and the way that that might impact your mental wellness. The high level of prescription psychotropic medication also raises concerns about the overuse of these medications for promoting compliance, or potentially the use of medications as chemical restraints on the population who's incarcerated as well. And finally, while some may argue that incarceration offers the opportunity for physical and mental health treatment, there's no evidence that favors prison-based treatment over community-based treatment. So when people tout that an in-prison program works, we need to ask, compared to what, right? Compared to nothing? Sure. Compared to being served in the community where you can sleep in your own bed and have privacy and bodily autonomy? Not so much, right? We don't have data on that. We don't have evidence that programs work better than keeping women at home. I want to turn specifically to age now. This is an issue that's getting more and more research in the criminal justice literature as our incarcerated population across the country ages. So the age of the female DOC custody population ranges from the youngest at 18, 19, all the way up to 77 years old with an average age of 41. And as you can see, the largest group in this population is the 30 to 39 category, followed by people in their 40s and 50s. Which means, as a result, is that almost 1/3 of this population is age 50 or older. Older incarcerated people face a specific set of additional challenges for their health and well-being. 50 in prison is not the same as 50 in the community. The incarcerated population experiences what some scholars have called accelerated aging that's attributed not only to experiences before arriving in prison, but also deficient living conditions in prison, like unsupportive mattresses, poor food quality, and interrupted sleep from the noise and the light levels while people are incarcerated, which I think the research is only just beginning on the impact of that sleep deprivation while incarcerated. Studies report particularly high rates among the incarcerated population of hypertension, diabetes, cancer, depression, impaired vision and hearing, and memory loss among older incarcerated folks. And they're also a greater risk of falls and injuries. More than half of older incarcerated women report difficulty carrying out what health researchers call prison activities of daily living, which can include getting up and down from top bunks, dropping to the floor for alarms, and standing in line for food and medications. So this graph shows the breakdown of sentence lengths among groups of older incarcerated women, showing that the older the age group, the more likely it is that the person is serving a life sentence without parole. This is because people in this age group are not out breaking the law, right, committing new offenses. They are the people who are sentenced at a younger age and have been incarcerated for many years. I crunched some numbers from a public records request, some data that we received, and looked at the days served among those sentenced to life with or without parole who are in this group, and found that they've served an average of more than 6,000 days or more than 16 years behind bars in this population. And again, some of these folks are in their late 60s or early 70s. Continuing to incarcerate women in these age groups makes very little sense under most explanations for incarceration, right? Under the justifications that the state has for holding people in custody, especially the argument about public safety, because people in this group have the lowest rate of reoffense out of any age group. It does not make public safety sense to continue incarcerating women in this age group. So by the numbers, we know that a large number of women in custody are eligible for release, be it through parole, medical parole, or clemency mechanisms. These mechanisms exist, but it's about more than just eligibility, right? It's about more than just whether women are eligible for these mechanisms. Eligibility means nothing if these mechanisms are not accessible or being used to their full potential, as Erin indicated. So to understand more about what it actually means to go through the parole process, I'm going to turn it over to our panel of folks with direct experience of parole. And if you would like to know more about what we know about the population of women incarcerated in Massachusetts, I direct you to our project website where we have some more reports and figures that are informative. But other than that, I will turn over to our next panel of experts, and I'm going to stop the Zoom recording while they speak.
Hi, everyone. My name is Patty Guerin. I've been working in the area of parole for many, many years. I'm a criminal defense civil rights attorney in Boston who's been concentrating on parole a lot for the last 20 years. And this segment of the program is called Pathways to Release. That's the ideal release. It's a really hard-fought battle, as you've been hearing. There's a limited number of ways to seek release once you're incarcerated, and they're all very challenging and time-consuming and difficult, but achievable for many women. And so it's worth to keep trying all of these different ways to get people out of prison. And everybody up here is going to talk about a different way, and I'm going to introduce them to you so that you know who they are and what they're going to talk about, but they're going to cover all the areas. They're going to go from parole to various kinds of clemency to criminal work. You've already heard from Eva. I'm going to talk about commutation and pardons. So I think we'll just get started, and everybody, a lot of people have their own PowerPoint presentations. Some do, some don't. But let's get started with parole. And here to talk to you about parole is Mara Vukidis, who's the director of the Parole Advocacy Unit at the Public Defender Office, CPCS. A lot of you may not even realize attorneys are now getting regularly appointed to certain parole cases, and that's Mara's work. She's figuring out who can get appointed counsel and when. She's going to talk to you a little bit about that, and she's going to talk to you a little bit more about parole process. Each of us are going to talk somewhere between 10 and 15 minutes. So this is going to be a short intro into these various ways to get out. But let's lead off with Mara.
Hi, everybody. Thank you for having me. I'm really glad to be here in support of women, incarcerated women, caregivers, and glad to be in this community with you today. The parole unit is a new unit, about 1.5 years old. And what I'm going to tell you is I'm trying to shorten, a pretty complicated area into a little brief thing. So I just want to encourage everyone. We love talking to people, and you're always welcome to contact my unit. We love talking to people who are incarcerated, people who have loved ones who are incarcerated, people who are concerned about someone who's incarcerated. We are there for lawyers, social workers, et cetera. We can be reached if you contact the main number of CPCS, 617-482-6212, and just ask for the parole unit. That should also work for incarcerated people as well. Sometimes they also have a speed dial from their prison, which they would know about as well. Fabulous. Okay. Great. So let me talk a little bit about what the unit does. The main role of the unit is to make sure that people who have a right to counsel, to assigned attorneys, free of cost, get attorneys. And so within that, we assign counsel for people facing parole release proceedings, certain people facing parole rescission and facing parole revocation. And we also now are in charge of the medical parole practice area as well. We have a very small staff. It's me and my wonderful administrative assistant and wonderful staff attorney. And then almost all of the cases are assigned to private assigned specialized counsel, who just the community of parole attorneys are phenomenal. 2 of them are here today, Kim Jones and Patty Guerin. So we support those attorneys, provide training, help them provide training to others, and that's a big part of what we do. So actually, this coming week, we're certifying 20 more attorneys to handle particularly non-lifer parole release and revocation cases. As I'll discuss, we haven't gotten a lot of cases from the parole board. He's supposed to send them to us, and so we want to build our capacity so we can really ramp that up and serve people. We also help people with parole questions, as I said. So we talk to a lot of people. They might not have a right to counsel, but they might have a question about parole. And so we're in touch a lot with parole board staff and back and forth trying to clarify things. Someone says, I don't know why I'm still here. We're going to try to help and get to the bottom of it, even if we can't assign counsel. We are liaison to the DOC as well in certain ways. Obviously, PLS, Prisoners Legal Services, they're the main legal entity for that, but we help when we can, connect them to PLS and that kind of thing. We really want to work towards making parole and medical parole more common and more sustainable, because as we probably here all know, parole release is really hard to get, and it's hard to stay released. The conditions are very onerous. There's a lot of racial and ethnic bias in the conditions themselves. So we're trying to work on all of those systemic issues as well. We also are working to reduce discrimination and ableism against people with disabilities who are incarcerated and also who are released on parole. That's a big focus of my unit, because those folks are really underserved. As someone with a disability myself, I really, am concerned about that. So let's talk a little bit about the standard for parole release. I think it's actually on one of these beautiful big things here. Essentially, it's whether there's a reasonable probability that if the prisoner is released with appropriate conditions and community supervision, the prisoner will live and remain at liberty without violating the law, and that release is not compatible with the welfare of society. And in making the decision, the board has to consider a risks and need assessment of the available work opportunities, what the person has done while they're incarcerated, et cetera. And so that is the standard. I wish I had more time to get into what these parole hearings look like, but lifer hearings are open to the public and they're public records. And so I would invite anyone to check out the hearings. The calendars are online. And it's really important to sort of get a sense of how it feels to be before the parole board. That's lifers. Non-lifer hearings are very fast. They're in the institutions unless they're victim access hearings, which are a different kind of hearing that are in NADIC as well. And it's really tough. It's not like court. It's a lot of questions directly to the person. It's a very high pressure environment, and it can be very traumatizing in itself because people are really asked to go through what happened and to talk about their lives and talk about their trauma. So let's really focus on who has a right to assigned counsel for parole and medical parole. For parole, as you may know, juvenile lifers have a right to counsel, so people that committed a crime and were sentenced to life prior to the age of 18. And they have a really strong right to counsel thanks to the Diachenko decision. People who are referred from the parole board for reasons of disability or other related access issues also should have an attorney. This is the area I mentioned where we really do not get enough referrals. And so we've been collaborating with the board to really increase their role in providing referrals to us. Particularly non-lifers are really under-referred for counsel. So that's an area where you can help. If you're in touch with someone who's incarcerated and you think that they might be eligible for an attorney due to reasons of disability, please reach out. We want to find those people. And you don't have to know exactly, we won't get into the exact standard, but just know that anyone that thinks they could use a lawyer or any loved one that thinks that might be a thing should contact us. We will do a pre-screen and we will let the parole board know you need to screen this person for counsel. People who are facing revocation also have a right to counsel, but again, that's through the parole board. So a little problem here is that the right to counsel attaches when we get the notice from the parole board. But I can promise you that my unit does its mightiest to really get those referrals to us. And with a lot more lawyers coming, we're really planning to ramp that up a lot. It's a little confusing, I can imagine, because during the pandemic, we were all over the place. So, or obviously we're still in the pandemic, right? According to, scientists, I guess. But for us, it was during the state of emergency, when it was considered a state of emergency in the Commonwealth, we were able to assign counsel a lot more freely than we can now. And so it's a little confusing to people. So if there's confusion on the part of an incarcerated person or a loved one, please be in touch about that. How does someone seek counsel? They need to ask their institutional parole officer. They need to say, I need a lawyer for reasons of disability, or I need to be screened for a lawyer. They can also contact us. We can make sure that that's actually happening, and we can put in a plug for that person to have a good, thorough screening. So there's a lot of challenges and opportunities with parole. There are way more people out there who are incarcerated that should have a right to a lawyer for parole, and we don't see them yet. We talk to a lot of people. We're trying to do what we can, but this has to expand a lot. Historically, we've received way too few notices. And the courts are not a great place for parole release because the parole board has a ton of power, a ton of discretion to make these decisions. So when things have gone up to the court, a lot of us have been pretty disappointed about the results. The opportunity is that it's an exciting time for this practice because there's new leadership in the parole board. And I think a lot of us are feeling really hopeful about reforms being made on that level. I just want to mention one other thing about parole, which is early parole. People might have heard of this. We don't assign counsel for this, but there is something called early parole consideration for people who are in the houses of correction. And they can ask to be considered for early parole consideration. If anyone has someone who they know who's in the house of correction and they want to talk to me about that, let me know. I'm happy to provide information even though we can't assign a lawyer. quickly on medical parole. So medical parole, if the commissioner determines that a prisoner is terminally ill or permanently incapacitated, such that the prisoner is released, the prisoner will live and remain at liberty without violating the law, and that the release will not be incompatible with the welfare of society, the prisoner shall be released on medical parole. Who gets counsel for medical parole? We can do a screening for anyone who thinks that they might be eligible. I don't think that we would do a screening for someone that doesn't, everyone agrees there's no health issues. You know, there might be some sort of cutoff, but I'm happy to talk to anyone that is incarcerated and has questions about this, and any loved ones, because an area of an area of growth that we need to do is people who might be cognitively disabled, who might not be able to communicate as well to us, their need for petitions. And when I'm talking about medical parole, I also want people here might already know, but Prisoners Legal Services has also been a real leader. I mean, more than CPCS, honestly, in medical parole. And so we've been partnering with them closely. So probably any good information you're getting on this section is from them. I just want to thank Ada Lynn and Prisoners Legal Services for their work. Also, a few other law schools provide counsel as well for medical parole, BC, BU, and Harvard. I think those are the ones. Medical parole was enacted in 2018. Prisoners are eligible if a physician has determined that they're terminally ill or permanently incapacitated and they don't pose a risk to society. Terminally ill means likely to die within the next 18 months. Permanently incapacitated can be physical or cognitive. The prisoner shall be released if that determination is made. As you can imagine, there's a lot of concerns about how the DOC, who's the entity responsible for doing this, is applying this law. The petition is submitted to the superintendent. It has to be decided within 21 days. Oh, sorry, it has to be conveyed to the commissioner within 21 days. And there's much more to say, of course, about all of these. I wish we had more time. Challenges and opportunities. Again, the DOC has so much discretion. And I think there's a lot of concern among advocates that this is an underutilized area because there's a real barrier to release, with the DOC being the decision maker here. I think the opportunities are that there's a groundswell of interest in this and advocates are working really hard. Another opportunity is for us to find those people who need counsel and make sure that they have a screening. PLS is doing a great job of that, and incarcerated people are doing a great job of writing to us and letting us know when they're concerned about someone. And that's it. Thank you so much.
Thanks, Mara. Okay, next, we're going to hear from Kim Jones. Kim Jones is an attorney who used to work at CPCS as a public defender. She's now a private attorney, and all of her practice is parole work. And she is this is encouraging for those of you who are lawyers who want to seek to do parole work. That's what Kim does full time, is parole cases. And right now she's working on setting up a very interesting project, and she's here to talk to you about it because it needs volunteers. And you don't have to be a lawyer. You shouldn't be a lawyer probably, because if you're a lawyer, you can take appointed cases. But Kim is going to talk to you about a project where we need lawyers to volunteer to help prepare people who are incarcerated for their parole hearing, who don't have a right to counsel, but still could use a lot of help getting ready for parole. And she's working with the Executive Office of Public Safety and DOC to get a pathway set up for non-legal volunteers to go into the prisons and help people get ready for parole. And she's also got another volunteer project to tell you about. Kim.
Great, thanks, Patty. Okay. So a quick thing about, I'm just going to call it Parole Prep because it's a long name, Massachusetts Parole Preparation Partnership. It's modeled after the Parole Prep project in New York. I don't know if anybody's familiar with it. There was a New Yorker article in 2019, and that's how I learned about it. And ever since then, I've been trying to figure out a way to get people together to start a project like this here. We finally have a group of people, community advocates, attorneys, people on parole, people inside. We've been meeting for a few years now to develop this project. We are finally at a point where it's gaining a little bit of traction. We're intending to become a nonprofit. We're not one yet. But we're hoping to start our pilot project early in the new year. We're trying to have some conversations, as Patty said, with EOPS and DOC about the implementation of it, because this is new to have community members who are going to come in to the prison and actually sit with parole applicants in private confidential attorney rooms rather than sitting in the visiting room. So it's something that we're really trying to work out and get some agreement on before it starts. A couple words about MPP's foundational beliefs. We believe that no one should be defined exclusively by the worst thing they've ever done. Everyone is entitled to be treated with dignity and respect and should have a meaningful opportunity to return home to their community. The reasons why a person committed harm the way that they did and how a parole applicant came to be in prison is often the tragic result of a lifetime of experiencing systemic and structural violence and personal trauma. And finally, the distinctions that are often made between people who commit crimes and those who are harmed are blurred. Victims, in quotation marks, and those who harm them are often from the same communities and each have occupied both roles at different moments. Oh, I went backwards. There we go. Oh, a couple more foundational beliefs. We hope to create spaces where relationships between people in prison and community members can thrive, because this is something that happens to some extent and has been happening for a long time, but we're hoping to sort of get more people on board and create more of these relationships, which can be so powerful and helpful to both parties. So we believe that parole applicants are inherently experts in their own lives and in the criminal legal system. And the MPP volunteers who we're calling partners, their relationships with parole applicants are relationships of solidarity and partnership. It's kind of like a team effort. So it's different from legal representation where you have an attorney who's representing you and you are the client. This is more of a collaboration and partnership that we're looking to have. And we want to bring forward the experiences of people in prison and those who have come home to help center and amplify their voices. So thank you to Terry Ann and Angie for being here today. That was so wonderful to hear about your experiences. We hope that a lot of people who have been in prison and who are on parole or family members will become part of this project because we need those voices. So yeah, as Mara kind of said, there's some legal representation that does happen for people serving life with the possibility of parole, but it is limited due to sort of limited assignment of counsel, limited law school parole clinic representation, and the cost of private attorneys. Some people do hire private attorneys, but I think it's a very small percentage based on probably, I don't think a lot of private attorneys do this, and maybe the cost is prohibitive. In terms of statistics, 2021 statistics show that represented parole applicants, so people who have legal representation, have twice the chance of getting parole than those who are unrepresented. So we aim to increase the parole rate for those unrepresented parole applicants. It would be great if every parole applicant had the right to an attorney, and I hope that happens at some point, but right now we don't have that, so we're trying to fill that gap. In terms of numbers, as of October 2022, we have 21 women in Framingham serving life with the possibility of parole. And as of 2021, we have 808 men serving the life with the possibility of parole. I've been doing this parole work for about 6 years. I've had one woman client because there's a big gap, a big disparity between how many women are in and how many men are in. But I'm really excited through this project to hopefully partner with everybody here to get more of those women help to either counsel or help from the Parole Prep Project. People on the inside have always been helping each other prepare for parole hearings. My clients always tell me about the amazing work that goes on in prison with watching video recordings of their hearings. People can request a video recording of their own previous hearing, or somebody on the outside can request, because these are public, so you can get a CD, put it in your computer, watch the hearing. So people inside have been doing this, watching each other's hearings, coaching each other, doing mock hearings, debriefing hearings afterwards, and also more formal parole preparation curriculums. I have a client right now who's created a whole curriculum as sort of a subgroup, or a whole program as part of a subgroup of the African American coalition in prison, and he's in Norfolk, and he's running this. He's had one parole hearing, and he's using what he's learned from that and what he learned working with me for, I don't know, 6 months before the hearing to help people. So we really want to partner. We have a couple people inside who are on our steering committee or board. We're not sure what to call it yet. But we're really hoping to sort of partner with the people inside and share resources and do what we can. Community support, both as people prepare for parole and after the parole applicant is granted parole, does obviously result in positive outcomes. So that's what we want to see. So the basics of the work is that we want to supplement the work that's been done by matching community volunteers, which we're calling partners, in teams of 2 with parole applicants. We're right now going to start the pilot project at Norfolk, but we're hoping that we can find a few women to include in that pilot project, so have some people at Framingham as well. The partners, as I said, are going to work alongside the parole applicants to collaborate with them and help them prepare for their hearings. A really crucial part of this is that partners and the parole prep organization are going to remain connected to the parole applicant once they're granted parole and eventually released. And that is something I've seen over and over as something that can be so helpful for the person that gets released. When I was in Patty's clinic in 2009, I represented a individual who, it was his first hearing. He was sentenced as a habitual offender. So he was eligible at 15 years for parole hearing. I represented him. He didn't get out. He kept going back every few years. You get what's called a setback, which is like, okay, the parole board says, come back in 2 years, come back in 3 years, come back in 5 years. And so I would go to his hearings and support him. He would get legal representation from the clinic at Northeastern. And just this year, he got parole, got to go to minimum, and got released like 3 weeks ago. I picked him up from prison, and I have been so honored to work with him and support him through this process. He's one of the people who doesn't really have family. So it's really helpful for people who are coming out of prison to have somebody, at least one person in the community who they can call. He's trying to figure out how to use his phone. I'm like, oh, you have an Android. I don't even know how to use your phone because I have an iPhone, but I'll try to find someone to help you. He wants to watch TV on the computer. I'm like, okay, I'll try to help you with that. But I'm happy to say he's already gotten a job and he's doing really well. And then we want to partner with community organizations to support parole applicants and their loved ones. And we've been reaching out to community organizations. If you're part of a community organization that we haven't been in touch with you, let's get in touch and talk about how we can collaborate. The partner's role and time commitment. So we've talked a little bit today about DOC volunteers who come in and do programs. The partners are not going to be considered DOC volunteers. They will be able to meet with parole applicants in confidential meeting rooms, send confidential mail, hopefully confidential phone conversations. The idea is that they're working supervised by attorneys, and so they're more in a paralegal role, although they don't have to be trained paralegals at all. So it's still considered legal work, similar to how people from Prisoners Legal Services might go into the prisons and maybe they're not representing someone in a specific case, but they're still talking to them about what their rights are. So it's not legal representation. It's not the unauthorized practice of law or anything like that, but it's people who are trained by parole attorneys, like Patty, like other people here, to go in and provide information and resources and support to the parole applicant. So as I said, they're going to work in teams of 2. They're going to have mandatory trainings, parole, racial justice, anti-oppression, lots of training. The time commitment is that they're going to work between 12 and 18 months with each parole applicant prior to their hearing. Sometimes if somebody has a hearing coming up in 8 months and we want to help that person, and we can help that person, that's fine. But what I'm hearing consistently from people inside is that they are really excited about this project and they want to be assigned to somebody 2 years before their parole hearing. And I don't know if that's quite, that quite works with getting volunteers to commit for 2 whole years, but it does take a long time to develop trust, whether you're an attorney or whether you're just a community person. And so 12 to 18 months prior to a hearing is a really nice amount of time to get to know each other. You don't have to talk about the parole hearing and the parole case every single minute that you're meeting or talking. It can be sort of more of a holistic type of relationship. And as I said, we hope that the partners will continue to provide support after the hearing, but it's not mandatory. If you can't do it, we'll find somebody else to provide support to that person. We think that it'll be about 2 to 4 hours per week on average doing this work. We want partners to attend monthly meetings to refresh their skills, and we'll try to have different trainings on different issues. And then, as I said, the pilot project is going to start in Norfolk. Right now, we have about 6 to 7 people who have parole hearings coming up in 2023 or 2024 who'd like to be matched with partners. And then, as I said, if we can identify, I have a little list right now of people in Framingham who have parole hearings coming up. So we're trying to work with them to see who's represented, who is represented by a law school clinic, and who needs help. And we want to be there for those folks. As I said, you don't have to be a lawyer to be a partner. And as Patty said, if you're a lawyer, you're taking cases and you're busy and maybe you don't have time to volunteer. But if you are a lawyer and want to do a different type of law or do parole law, you can still be a partner. But so students, social workers, lawyers, teachers, people who have loved ones inside, that's a big one. We want people who have experience with the system to come and to work with us and to work with other people inside. People who have lived experience are the most important in terms of voices that we want to amplify. People who are unemployed, people who are retired, anything. And as I said, we're going to train partners and provide ongoing support and supervision from experienced parole attorneys. And to learn more. Okay, so there's a partner application online, and I figured out that instead of like these 2 lines of inputting stuff, you could get a tiny URL. I'm very unfamiliar with that thing, but I put it up there. It's like 8FB, whatever. You can copy that, or you can email me, or you can talk to me. There's a group of us here from the Parole Prep Project in the back corner. You guys want to wave your hands? So you can talk to any of us about how to get that application. Other ways to be involved. If you can't commit to being a partner and you can't commit 12 to 18 months, that's understandable. Maybe you're a social worker and you can provide consultations to a partner. That would be amazing. Facilitating trainings for partners, for example, like a training on trauma-informed practices, if that's your expertise. I think the partner volunteers would love that and could really use it. Fundraising or starting a nonprofit experience. I have no idea what I'm doing in terms of starting a nonprofit. So people that have experience with that, I would love to talk with you. I also am not on social media at all, so I definitely am not equipped to start a website or social media for this. So if you have experience with that and want to help, great. Do you have a connection to a space where we can hold our first training? This would be an amazing space. That would be amazing. Funding. If we do need a little bit of initial funding before we become a nonprofit. So if you're somebody that has access to some funding, we want to use that for printing training materials, giving a stipend to some of the incarcerated and formerly incarcerated board members, travel expenses. And then finally, joining Parole Watch. Parole Watch is a volunteer group of experienced professionals and concerned citizens that monitors life sentence parole hearings in Massachusetts. So you can learn more about that. I don't have time to talk more about it now, but you can speak with Lisa. Lisa, raise your hand if you want to learn more about that. And then her email is here if you want to email her, berland.lisa@gmail.com. Parole Watch is amazing. And I think that having people in the parole hearing room who are holding the parole board accountable for what they say can be very, very powerful. I think that if the room is packed, I think the parole board is hopefully going to be on their best behavior rather than throwing out obnoxious questions. So Parole Watch is amazing. So that's another way to get involved. And I think that's it. Thank you.
Thanks, Kim. One thing that Kim didn't say is that if you join Parole Watch, we do ask you to go and attend a parole hearing, but you take notes. You're given a chart sort of to fill out about how board members act and what happens at the hearing and how people interact with the person who's up for parole. And what ends up happening is we get all of that data. And then when the person comes up for renomination by the governor, the Parole Watch people go in and testify before the governor's council about why they shouldn't reappoint someone or how representation should change. And it's incredibly helpful to have these voices of people who've been sitting in the hearing room taking notes on what the board members do during the hearings. And you can also participate by watching some of them on video. You don't have to attend, we'd like it if people can go to one hearing a month, but you can also watch them on video. So it's a fun way to get involved that doesn't involve a lot of work, but has a pretty strong impact. One other thing that I forgot to put on this list, and then Mara just reminded me we should say, is that it's true, it's difficult to get appointed counsel for parole hearings because you have to fall into the category of being disabled to the point the parole board thinks you can't represent yourself, or you have to be a juvenile lifer. Those are the absolute, you're entitled to counsel. But there's all these other prisoners that don't have counsel. With respect to lifers, everyone should know that there's 3 clinics that provide representation at lifer hearings, and that's at Northeastern, Harvard, and BC does parole release hearings for lifers, and they provide terrific representation as we continue to work every day to try to expand the right to counsel. I mean, we'd like to have an automatic right to counsel for parole revocation hearings and rescission hearings, because the people are out in liberty and having something taken away from them. And so your mind tells you you ought to have counsel if you're losing that liberty interest. So that's an ongoing battle that the parole advocacy unit is pushing forward. But remember, there's clinics, and there's also a clinic that does medical parole at BU. So there are skilled attorneys out there supervising law students and providing good representation. And before I talk to you just a few minutes, because now we're behind on, I'm going to talk to you a minute or two about pardons and commutation. But before that, one other thing I forgot. I mean, here we are telling you about the ways to get out of prison, and it's parole and medical parole and commutation and pardon and criminal action. There's one big area that I forgot to put on the list, and that is legislation. There is a huge, important need to change legislation, and we have some wonderful legislators here today who have been about that and are working on that. There were some really powerful parole bills filed last session. They didn't go all the way through. They stopped in committee, but they had important changes to parole, changing the standard for parole, changing the burden of proof, changing the board members, doing a lot of things that's going to add up to more people getting out of prison. There's bills that'll be filed about life without parole sentences. There's going to be all kinds of things filed legislatively. So I can't urge you enough to pay attention to what your representatives are doing and try to support them, because I see that as a very important way to change. And the legislators are going to be part of groups this afternoon, and they will welcome your comments and they'll talk to you about their ideas for changing legislation. But it's a really important way to get more people out of prison in a really just and fair process as they help to improve the system.
Patty, can I add one thing very quickly? There's a case pending right now in the SJC that might really broadly expand the right to counsel for people who are emerging adults, people that committed their crimes at 18 and were 19 through 20 until 20. And so that's pending. It's really complicated. It hasn't been decided. We don't know what's going to happen with it, but please reach out if you have questions about that.
Okay, I'm going to talk to you about getting out of prison via commutation or pardon. I'm going to speed through this because we're a little bit behind, and there's a lot of, there's a wonderful website that was put together by Laura Burnett and Pauline Kirion, who you're going to be hearing from in a minute, about it. And I urge you to look at it. It'll be in the materials. But clemency, what is clemency? In Massachusetts, clemency is 2 things. It's either a pardon or a commutation. What's the difference? A commutation is you're asking to have your sentence reduced. You still have a guilty on your record. It's not going to change the fact that you have a guilty on your record, but it's going to reduce the sentence. A lot of people use a commutation to get out of prison when they're serving a first-degree life sentence. I say a lot. not a lot in the last 2 decades. Before that, and we've had 3 in the last year, but I'll speak to that in a minute. But that's a way to get a first degree sentence commuted to second degree, and then you can get out on parole. So commutation reduces the sentence that you're serving, the number of years, and a pardon excuses it completely. If you get a pardon, you no longer have that criminal conviction. And the point of a pardon is supposed to be allow you to reintegrate. Oftentimes, a criminal conviction on your record makes it impossible for you to get certain kinds of housing, for you to get certain kinds of licenses, for you to get certain things that you need to be able to succeed in life. And so those are the folks who seek pardons. To get a pardon, you have to already be out in the community, successfully out in the community. So the thing that's tricky about commutation pardons is that they're governed by this thing called the governor's guidelines. Clemency is mentioned in our Constitution as a right that people have to move to reduce their sentence or to eliminate their conviction. But it doesn't give a lot of detail on how it's done. It just says that's a right that everyone has, they can use. And there's not many detailed regulations about it either. But the Constitution provides that the governor shall write guidelines, and the guidelines will govern commutations and pardons during that governor's term of office. So these guidelines change from governor to governor. And that's sort of distressing because we had a fairly decent set of guidelines when Deval Patrick was in office. It was one of the things that he had done somewhat better. And then Governor Baker came in and the good guidelines disappeared. Under Governor Patrick's guidelines, you could use a commutation to undo an unjust sentence or undo an unjust conviction. And that was an important guideline, that would be what it was used for. Under Baker, those were eliminated, and it was only used to reward extraordinary conduct after your conviction. And I mean extraordinary conduct. You might have read about the few people who got commutation so far, and if you did, you'd see that they had these absolutely phenomenal prison records. You could not believe the things they accomplished program-wise, prison-wise, behavior-wise in prison. Those are the people who have made commutation. And in the last 15 years, there's only been 3 people granted a commutation out of all the people who have applied. Right, there you go. As Eva just said, Angie didn't even get a hearing. So incredible. I mean, the process is, let's see, I'm trying to keep up with the PowerPoint and eliminate things as I go. But let's go to the page that says clemency has 3 steps. First thing you do if you want to get clemency, and I'm using clemency, remember, to mean commutation or pardon. The first thing you do for clemency is you put in an application, and that goes to the parole board. When the parole board is voting on clemency applications, they put on their hat called Advisory Board of Pardons. They're the exact same thing as the parole board, the same 7 people. So you send in your application to the parole board for a clemency. You send it to the governor's council as well, so they both get it. There's an application online at the governor's council website that you fill out to apply for pardon or commutation, but you mail that along with your memo as to why you think you deserve either a pardon or a commutation into the parole board or advisory board of pardons and the governor's council. The parole board looks at this application and they decide whether you have followed or met the governor's guidelines. But the governor's guidelines aren't mandatory. I mean, they're guidelines, so you don't by statute have to comply with them, but the parole board pretty much treats them as the rules of the game. And if you haven't complied with them, you're going to have a hard time getting a positive vote from them. But you put in your paperwork, and that's letters from people in the community talking about how successful you are, program things you've completed, stuff about your conviction. It's sort of like a parole package, frankly, only you're asking for a different kind of relief. Rather than parole, you're asking to lower your sentence. But we have samples to show people, and we can help everyone figure out how to do it. It's an interesting process because you're trying to comply with these guidelines that don't really have to be complied with, but so you send that in, and the parole board is supposed to review it within a certain number of days. They never do. I've had put in applications for clemency and had them sit for a year without the parole board reviewing them, even though they have a limited number of time by regulation to review them. But again, all these guidelines might be changing when Mara Healy takes over, and all the guidelines that are in this PowerPoint might be changing when Mara Healy takes over. Hopefully they will. There's a group of us trying to draft new commutation guidelines right now that we're going to be submitting to her. But anyways, if the parole board decides, or the advisory board of pardons decides you've met the guidelines and they're going to recommend, they're interested in recommending clemency, they'll schedule a hearing for you. They schedule almost no hearings. They've held exactly 4 hearings in the last 15 years. 3 of them were approved. That's it. So this is a tough remedy to get, at least for now. And I'm going to talk to you a minute about the changes in the parole board that are encouraging me that things are going to change soon because we have different people on the board. But anyways, if the governor, if the parole board approves your application for pardon or commutation, it then gets sent to the governor's office. The governor, believe it or not, has a year to decide whether or not to sign off on it. If the governor doesn't sign off on it in a year, it's automatically deemed denied. If the governor approves it, it then moves over to the governor's council. The governor's council is this, maybe everyone doesn't know the governor's council, because why should you? But the governor's council is this group of 8 elected people. You all vote on who you want your governor's counselor to be. They're down at the bottom of your ballot. This is the person that selects all your judges, all your parole board members. It's an incredibly important job that none of us really pay a lot of attention to, that we're trying to drum up interest in to get better candidates sitting on the governor's council, because it'll make a big difference with respect to who gets approved for judges, who gets put on parole boards. And they also approve clerks of court and some other positions, but mostly judges and parole board members are incredibly important jobs. So there's 8 governor's counselors, and they then conduct their own hearing using the same standard. Have the guidelines been met? Do they think this person should be commuted? And they vote on it, and you have to get a majority vote of the 8 governor's counselors. And so if it's a tie vote, then the lieutenant governor casts the tie-breaking vote. And generally, if you're doing a first-degree murder prison sentence, what they end up doing is commuting it to second degree. And so then you have to go and see the parole board to get paroled on second degree. So you can see what a long process this is, but it has worked successfully for 3 people in the last year. With a lot of work and a lot of effort, 3 people have had their sentences commuted from natural life sentences to parole eligible sentences. And they're going to be out. Well, 2 have had it completely, and the third one is almost through the process, still has to have a governor's council hearing. But it's a very tough process. I think that if you look at I'm not going to spend too much longer, but if you look at the what's up on the screen and what will be in the materials, this is some information about who has the burden of proof and how tough it is. You have to prove that you meet the guidelines by clear and convincing evidence. The things they look at really closely are the nature and circumstances of your underlying offense. And they also look at your character, and this is particularly important, what your character and behavior has been since the time of your offense. So what has it been in prison? And if you're looking for a pardon, what has it been since you got out into the community? Then there's a list of factors that sort of are favorable to getting a commutation. Those are probably common justice, common sense things if you go through them. Have you accepted responsibility for the offense? Have you been involved in restorative justice? Now, remember, these are Baker's guidelines. You didn't used to have to accept responsibility for the offense if you were saying you were not guilty and you were using a commutation to get out of prison. Under Governor Baker's guidelines, you have to accept responsibility. That hasn't been the part of most guideline systems in the past. And hopefully Mara Healy will change that back to the way it used to be, that you can use a commutation to get out from under a wrongful conviction or an over conviction or overreaching sentence or something like that. The next page is just other factors that they consider. Again, they are looking at your conduct mostly, at least under Governor Baker's guidelines, it's conduct driven. What has your conduct been in prison? What has your conduct been since, if you were looking for a pardon, since you got out into the community? Then there's a list of factors that do not favor commutation. They don't look to commuting people's sentences on a first degree unless they've already served 15 years. That's sort of a consistent standard that's gone through most governors of keeping that in place. That's because most first degrees are seeking commutation to second. So they want you to have done 15 years. They want to make sure that if you had restitution, that you've paid for the restitution. If you have a lot of disciplinary reports, they want to make sure you have at least 1 year of solid conduct, good conduct in prison. On the next page that starts out with pardon for a conviction, there's one big typo that I want you to correct if you're going to look at this or use it, which is it says that if you're looking for a pardon, you have to, under Governor Baker's guidelines, you have to have had at least 5 years. You can't apply until you've had 5 years past any kind of supervision, parole, probation, whatever. You have to have done 5 years in the community with no kind of supervision. And if it's a felony, the slide says 7 years, it should say 10 years was Governor Baker's guidelines. Again, this might change when Maura Healy gets in. These are simply guidelines. One thing that I think would be helpful to look at is the MBA clemency report, and that's the last page of this. There were a bunch of people who sat on this commission from all different kinds of jobs, lawyers, legislators, other advocates. It points out what's wrong with the clemency process, where it needs help, where it needs to change. It's a very weak system right now. It's not really what I would call usable and productive. I'm hoping that it'll get some energy when we get new guidelines for Maura Healy that speak to really using clemency and pardons to get people out of prison. And there's one other thing I would ask you to look at, which if you send anyone here an email, we can get it to you, and maybe I'll even get a link to it up before this afternoon, which is there was a commission on structural racism in parole, which also looked at structural racism in parole and commutation. That's all part of what the parole board does. And that report, which was a report, as Jamie Eldridge just mentioned to you, that he was head of the commission with Rep. Andy Vargas. It's got a lot of really good information about what's wrong with parole and good recommendations for things that need to change. And one of those things is this commutation process, which is just way out of step with what it should be in today's day and age. So I think I've gone way too long. So we're going to stop with commutation and pardon, and we're going to move on to a little more information about that with, let's see, Pauline is next, right?
Yes.
So Pauline Curion is an attorney at GBLS. She's head of the Corey unit there. She knows more about sealing records than anybody in the state. And she's going to talk to you a little bit more about the clemency process in Massachusetts.
Okay. In the online materials, there's a handout called Clemency 101, and on the second page, there's a link to the Mass Bar Association Clemency Task Force report, and I co-chaired the Mass Bar Association Clemency Task Force, and we were fortunate to have Patty also involved on the task force, and lots of other terrific people. And essentially, what the Mass Bar Association Clemency Task Force report does is it calls on Governor Baker to overhaul the guidelines, primarily because the guidelines, as they're currently written, are unfair, and they're really structured to make it really difficult for people to get through the clemency process and also to ever succeed. And as Patty mentioned, it's just been decades and since anybody even got a commutation, and clemency has just become a rarity. So I'm just gonna we don't have a lot of time left, so I'm just gonna go through some of the highlights of the report. And what we have in mind for the future is to reach out to Maura Healey as governor to write a really good set of guidelines that are, number one, that are fair to people, and make and revive clemency as a process that can actually be used by people, who it's doing no good by continuing their incarceration, and maybe they shouldn't have been there to begin with in terms of the sentencing. So the first part of our resolutions, with the first suggestion we made, was a resolution saying that the guidelines should acknowledge that clemency is a vital part of the criminal legal system, and historically it was recognized as a really important part of the legal system, because even at the time when Alexander Hamilton and all these other people were, these other white guys were getting around working on the Constitution and framing the government, it was recognized that the criminal legal system doesn't work even back then, and so you need a safety valve to be able to fix some of those problems. So that's the first thing, is we had suggested that the role of clemency has to be revitalized and recognized as being vital. And if you look at the governor's guidelines, they're also written in a very negative fashion. I think people are generous in terms of how they characterize the guidelines, and even the Patrick guidelines, which are better than the Baker guidelines, they're very conservative, and it's kind of withholding of helpfulness in terms of the way that they're written. So one of the second resolutions in terms of the MBA report was to recognize racial injustice in the criminal legal system. So and so that should be a factor that's weighed, and so that should be a goal of the application of the guidance, is to recognize the racism that exists in the legal system, and to apply clemency in a way that it can be used as a tool to mitigate that racism. So that was our second resolution. Our third resolution had to do with the procedural aspects of clemency. If you there's actually a clemency statute, and it says they're supposed to, after you apply, in 10 weeks, something's supposed to happen. So it's actually in a law. It's not just the governor's whim, but it's pretty much horrible. I mean, people, I think your client, he waited like 6 years to get a hearing.
Yes, I filed a clemency petition and waited 6 years before it was ruled on. So much for the 10-week rule, right?
So we made some recommendations about, sticking to time standards, and even the courts have time standards when, within a certain amount of time, something's supposed to happen, though they also violate their own time standards, but that's a big area for improvements. And some of the procedural aspects are just really frustrating. I know with the two clemency hearings that I either watched or I listened to, they didn't broadcast it on Zoom. You had to listen on the telephone, and it's really difficult in terms of it being open to the public. I thought fundamentally that was wrong. And then I think for the second clemency hearing, I actually was allowed to go to Framingham, because I've had a ringing ear for the last 20 years, and I wrote a letter, and they said, well, we're not going to let you Zoom, but just come. It's like, I think they expected me to say, oh, I don't want to bother coming. So I did go there, and I was the only person in the audience, and there were plenty of chairs. So it is uncalled for that these hearings aren't open to people and also available through Zoom, since they Zoom to their own members. Only part of the advisory board was there for the actual hearing. So the guidelines need to be set up so that they've got strict deadlines that are met, and also that, you know, these hearings are available to everybody. Moving along, we had another guideline having to do with some of the substantive problems with the clemency process. You know, as Patty pointed out, is under the Baker guidelines, you have to take responsibility, but you know, people get convicted and they're innocent, and the goal of the initial creation of clemency was that you'd have this safety valve, but it sort of defeats the whole purpose of it if you have to acknowledge that you're guilty of a crime you didn't commit. So we called on the governor to basically get rid of that part of the guidelines. And again, looking at racial disparities, looking at the person's circumstances, you know, at the time of what was going on. The other thing about the Baker guidelines is they punish you for taking a lot of appeals and basically just exercising your constitutional rights. So that was pretty outrageous. I think it was at Mr. Kuntz's hearing, he really got grilled on the fact that he had taken an appeal and just exercised his legal rights. I mean, that's pretty outrageous that, you know, that factor can be used against someone. So we've got some other recommendations. Like I said, I'm not going to go too much into detail because we don't have a whole lot of time. We did write one resolution having to do with the role of clemency for survivors of sexual and domestic violence. And, you know, clemency is supposed to be a humanitarian remedy, but if you think about people who are incarcerated, a lot of women and transgender folks in particular are disproportionately experience domestic violence, sexual violence, and may have histories of trauma, and then by being incarcerated, they're further traumatized by that experience. So that would make the person's history a relevant factor in terms of getting clemency. You know, obviously, you know, being incarcerated is not a place to heal from being traumatized before. And if anything, people just leave with, you know, leave incarceration with experiencing more trauma on top of the prior trauma. And then we had another resolution having to do with considering the age of the person at the time of the offense. And this particular recommendation had to do with the fact that a lot of young people get involved in the system, and it's really hard to get out of the system. But, you know, at the time, in terms of these clemency guidelines, they don't factor in all of the scientific advances and all of the literature, including the SJC decisions having to do with brain development. So if the brain isn't fully developed until your mid-20s, so that also should be a consideration in the clemency process. And then we had another resolution having to do with clemency for folks who are elderly or frail or chronically ill. You know, Massachusetts has the dubious distinction of actually leading the nation in terms of the number of elders that we incarcerate in Massachusetts. I mean, that's really something that should change. It's really expensive to have people who are sick and elderly or have dementia and to keep them incarcerated. Fiscally, it makes no sense, and also it's just cruel and just you know, really offensive that kind of situation exists in Massachusetts. We had some other resolutions to change the parole board, and as Patty has indicated, there's been legislation on that in the past. That's something we all should work on supporting. We also had a resolution having to do with pardons once someone gets out. The current guidelines, they make you come up with a letter showing that you were rejected for employment specifically because of your criminal record. And I know from doing lots and lots of sealing cases is most of the time when somebody finds out you got a record, you don't get a call back, you don't get a letter, you don't get any kind of minimal courtesy. So most folks are not going to have those kind of letters. And we have an SJC opinion that specifically recognizes that, called Commonwealth versus Pond, that it's unrealistic for people to have that kind of documentation. But not even though you're able to seal records, the pardon can make a big difference if you want to work in early education and care, and in the child care field. If for some reason you want to get involved in law enforcement and a lot of government positions, it would be helpful to also have a pardon. But again, the guidelines of anything just create a lot of hurdles to getting relief, as opposed to giving you a pathway to relief by setting for something other than taking a lot of the programs that are offered or not offered, so that the expectation is rather, unreasonable. So those of us who are on this Mass Bar Association Clemency Task Force, which is it's a bar association group, so granted, it's a bunch of lawyers getting together, and we have even prosecutors who are part of this group. We're going to try to take these recommendations that we came out with and come out with a set of guidelines, but I think it's important for everybody to have input. So we're going to have a breakout group in the afternoon, but I think everybody should be contacting Mara Healy and urging her to come out with a really usable set of guidelines so that people can actually get clemency.
Thanks, Pauline. We have 2 more people to speak, and as Pauline just said, the purpose for writing these guidelines and spending so much time going over them or writing these recommendations was to change them. It wasn't just to have a written document like these are the Bar Association's recommendations for change. It was to change them. So our goal is to draft regulations that reflect a way to get out of prison, a realistic way to get out of prison, and to undo unjust convictions, and to make a lot more sense out of guidelines that right now make absolutely no sense. So hopefully that's going to be coming. And on top of that, well, first we're going to hear from one more person about clemency and the guidelines. The last person will be Eva, and I think we'll still be finishing on time because we got back on schedule. So,
Well done, clemency folks.
okay, so Laura Burnett is a staff attorney with the Women's Bar Foundation, and she runs the Women's Bar Foundation Clemency Project, and she's going to tell you a little bit about that project and try to encourage you to get involved.
Yeah, thanks, Patty. So yeah, I'm with the Women's Bar Foundation and our Clemency Project, where we're filing commutation petitions for clients, is our newest pro bono project. So we're really excited about it. We're relatively new to this area, and we've been learning alongside with all of our volunteers and working together and supporting each other. So it's been a great experience. Like I said, we're representing clients in filing petitions for commutation. We are generally serving elderly women, which, because of the accelerated aging that we heard about earlier this morning, elderly starts at 50 for our incarcerated clients. We're looking for clients who've served at least 10 years and for whom parole and other remedies are not available. These guidelines are really flexible. We're looking at applications as they come in, and most of the time the question we're really trying to answer is, can we help here? Is there room for our advocacy? Can we make a difference? And if so, if someone doesn't necessarily meet one of these qualifications, we're generally looking to provide assistance and help get a petition filed anyway. So we are looking for volunteers. We have several great volunteers, and like I said, we're all working together so far, and we're looking for more. Many of our volunteers are attorneys. Most of them are working in teams. And we also have social workers who are volunteering with us to look for community reentry services for clients, maybe do biopsychosocial assessments. help to get records, review those records, and generally just help to improve the petitions that we're filing in any way that they can. And Norma, who we heard from this morning, is helping to recruit the social work volunteers and facilitate that. So if you are a social worker who volunteers with us, you'll likely, have guidance from her, which has been really great. Also, people who are not social workers, not attorneys, but just looking to get involved can work with us and do paralegal type work. They can support the teams in reviewing records, filling out forms. And one thing that's really important is they can help to keep up communications with the clients. Our attorneys are volunteers from many different areas of law. They don't always have experience with communicating with individuals who are incarcerated, and it just can put up an additional barrier to keeping the client updated, which is really, it's really hard on the client, and it's difficult on the relationship, and the clients really appreciate, being kept up to date, of course, as anyone would, on what's going on with their case. And so that's something, facilitating communication, that folks who aren't necessarily attorneys or social workers can get involved in and provide support with. So as an organization, the Women's Bar Foundation provides a few things to facilitate this representation. We'll get you background information on the client. We are constantly putting on trainings. We just had a great training on some postpartum issues and postpartum psychosis that can play a role in some of the cases we're handling. And we continue to put on live trainings, and most of those trainings are recorded. And so I can get you access to the links for the recorded trainings. We also have a comprehensive manual that's been created by Pauline and is being updated regularly. So it provides you with the up-to-date information you need to walk through the filing of this petition. And we provide mentorship as well as access to a listserv where you can ask questions and brainstorm with the other attorneys and social workers who are working on these cases, and share documents and just get support in whatever's going on in your case. We also provide liability insurance for the attorneys and the social workers. So if you would like to get involved, please contact me. You can find my email address on the staff page for the Women's Bar Foundation, and let me know what capacity you might be available to volunteer in. I'll get you the training materials, I'll get you on the listserv, and I'll work on referring a client to you. You can get in touch with me even if you're not ready to take on a case right away. And feel free to get in touch with me if you'd like to work as a part of a team, but you don't have teammates in mind. That's absolutely fine. I can find individuals to match you with, either attorneys or social workers or other people to provide support and work together on these petitions. And if you do get in touch with me, just keep in mind these petitions, the gathering of information, getting to know your client, putting together a solid petition, filing it, waiting for hearing, this can all take a lot of time. And so if you, for example, are a student who want to get involved and you have a lot of time over the summer, but then once the semester starts, you might have less time, just make sure to let me know that up front, because we'll need to think creatively about exactly how you can get involved and how we can use that time if you're not able to commit for the long chunk of time that these cases can sometimes take. And just the last thing I wanted to note is, if you don't have a lot of experience, please don't let that stop you. Like I said, we're new to this area and we've been working together, learning together. We have wonderful support from many of the individuals in this room. And so please don't let your lack of experience, if that's something you're concerned about, be a bar to getting in touch and potentially getting started.
Thanks, Laura. Just one other comment about this. In case it wasn't clear from what I said, working on a commutation petition or a pardon petition is volunteer. There's no path to getting appointed counsel for a commutation or a pardon. So it is really a volunteer project. The one thing I will tell you is that I have worked on several of them. I've worked on two that are one that's definitely successful and another one that's going to be successful this year. And it is, it's an absolute joy to be able to work on one of these and to write them and to work with these people who are generally just so deserving of a commuted sentence or a pardon. I just filed a pardon application too for someone. It's really fulfilling work. It's really satisfying when you're able to get someone out of prison. It takes a lot of time and commitment, but it's an incredibly satisfying, worthwhile project to get involved in. So really think about contacting Laura. And so our last speaker in this panel is Eva Jellison. You've already heard from Eva before because she represented Angie Jefferson. Eva is a criminal attorney. She works at Woods and Nathanson, and anyways, she works there. I won't go through any more details than that, except she's a great appellate lawyer, trial lawyer, and now we hope a parole lawyer. So
Yeah, I'm getting really into it. I've gotten 2 clients released, so.
here
Yeah.
is Eva.
So I had a PowerPoint. It might show up, but if it doesn't, I'm just going to go off of kind of what I know. So I'm going to talk about post-conviction litigation a little bit, and this is going to be a 1,000-foot overview because it's a really complicated area, and no one should be practicing it who isn't an expert or supported by an expert. So this is not a volunteer thing, but I wanted to give you guys a little bit of a sense of when post-conviction litigation is available, and maybe some red flags, some layman's terms of, what I might hear if I'm talking to someone who's incarcerated that would say whoa, I should go get them an attorney from CPCS or from one of the innocence programs, either the CPCS innocence program or BC or the New England innocence program or some of the ones that exist. So there are a couple of, so this is post-direct. So everybody, you have a trial, you get convicted, you have a direct appeal by right, and you have a right to an attorney during that appeal. So we're talking about after that. So after that, I'm only going to talk about 2 mechanisms. There's some other funky stuff, but one of them is a motion for a new trial. It's under the Massachusetts Rules of Criminal Procedure 30B. And you can apply for one of those at any time if, and I have the actual language, but essentially if your conviction is not just, let's put it that way. It's very broad, and the courts have kind of fashioned rules around it. So some specific buckets, we look at the behavior of trial attorneys. Could your trial attorney have done something different than they did? A lot fits into there. Could your attorney have hired an expert? Could your attorney have called a witness that they knew about, but they didn't actually call? Could they have raised the fact that you had mental health struggles? Was that relevant? Is there something that the jury did not hear that we think is relevant to this conviction? And that's how I would put it in lay terms. If you're talking to someone who's incarcerated, and Angie, do you mind if I use you as an example? So with Angie, it was really relevant. Her mental state was really relevant. This was a murder conviction, and your intent is incredibly relevant to what degree of homicide you're convicted of. And she had been the victim of abuse. She had complex trauma in different ways in her life. And when I talked to her about everything, it seemed very relevant to me. Also, her age, she was 20 years old. So we hired an expert, and we got a great evaluation about how that complex trauma and the fact that she was still an adolescent would have contributed to, that period of her life and that specific day. And I had to frame that as the attorney's fault because he didn't hire an expert. He didn't investigate an expert. So it's those types of things. What didn't the jury hear? Is there more evidence? Is there something that the jury didn't hear? That kind of falls into that Rule 30 bucket. And even if someone did not have a trial and pleaded guilty to the offense, Rule 30 is still available. It can also be used to withdraw a plea. The circumstances that you can withdraw a plea in are a little bit more limited, but you can still look into whether or not, somebody, the most important part, pleaded guilty knowingly, intelligently, and voluntarily. So that can incorporate a lot of different things that might have been going on in that person's life. You can look at the colloquy and whether or not the judge said the things that they were supposed to say. You can look and see if whether or not the person was competent. You can raise claims of actual innocence. So we have this mechanism, and it's available at any time, and it's also available in successive petitions. So the Rule 30 that I filed for Angie wasn't her first Rule 30, it was actually her second. And although some claims get waived and it gets more difficult, These can be filed at any time if justice was not done. So they're a way to get back in front of the courts. And it's especially important in first-degree murder cases because it's life without parole. A lot of these, parole isn't available. Medical parole would be, clemency would be, but they're very hard to get. So this can be a way to get someone out from under a conviction. So whether or not that conviction is first-degree murder or just an unjust conviction for another reason that has a long sentence, we would want to take a look at that. And then there's one other mechanism, which is Massachusetts Rule of Criminal Procedure 25B2 second sentence. You can also file those at any time. And that's more about what actually happened at trial. So in that circumstance, we're looking for like, how did this person get convicted on this evidence? The evidence was really thin. The weight of the evidence was against the conviction. After I heard all of the evidence, I really thought the jury was going to go with second-degree murder. I really thought the jury was going to go with manslaughter. I really thought the jury was going to acquit. I just can't possibly understand how this was even sufficient for conviction. And that's kind of the story that we're looking for a 25B2. So that mechanism has been used in a lot of cases too. The Suffolk County District Attorney's Office was using that a lot with the Conviction Integrity Unit. It's not supposed to be about new evidence, but whatever. So, so that's another legal mechanism. So if you were working with someone and they've not had a motion for a new trial, even if they have, if there's something new in their case that you think could be helpful, contact CPCS. And attorneys can contact CPCS, the incarcerated person themselves can contact CPCS, and they can contact both the post-conviction folks to get appointed counsel, or the innocence program to get appointed counsel, and they have different forms associated with that. And I had the web addresses for that in my PowerPoint, but I can get them to people. So yeah, that's my little pitch. Sometimes you need litigation to help people out. And if some of the things that I said are kind of like, oh, like I have a friend who's been saying some of these things, ask them about it. Help them contact CPCS, get them a lawyer to screen their case, and maybe something can be done for them. So that's what I got.
Thank you. That was great. That was so quick. All right, so what time is lunch? 12:30?
I believe so. Do we have questions?
So now we can do questions because we don't actually have to break for lunch for a while.
That was efficient.
You were
We do
very
have one
efficient.
online, if I could read you a question that was made earlier about medical parole.
Okay, let's hand
So,
that down to Mara.
Yeah.
Yeah.
Yes. An online participant asked, they said a point was made that medical parole should be requested on an incarcerated person's behalf. Can the speaker address the ways that the DOC itself may have granted medical parole during COVID? Were there situations where that happened? The person was asking a question about
So like if
substance
the,
use.
whoa,
Sorry.
oh my gosh, sorry. I hope people could hear me before that. So I think that it sounds like the question is whether the DOC initiated medical parole for people who are incarcerated. The thing that stands out the most for me, and that this might be referring to, is that during the pandemic, there were a few cases where the person, the DOC sort of scrambled to get medical parole for some people who were very close to death. And that we actually, I don't think my unit wasn't involved in those cases yet, so I don't have a ton of information about them, but it was very troubling to a lot of people because it seemed like it was a matter of not wanting to have the person on the roster as having died in DOC custody. And that happened, I think, I don't recall how many times, 2 or 3 times, I think. And I believe that the deaths were COVID related. So COVID was the height of the pandemic, was a time that a number of people were seeking medical parole, and very upsettingly, that was something that happened during that time. But in general, wouldn't it be great if the DOC initiated medical parole petitions? And I wish that Ada was here from PLS just to speak on that, because I think that's an area where everyone thinks that the DOC could certainly do more. We're doing a lot of fishing for people who might be eligible.
And just as to back up what Marge has said, that absolutely happened. We had very specific cases of people who had very severe diagnosis and had been trying to get out of prison for quite a long time prior to the COVID. And then when they got COVID and got very sick very fast and were put on ventilators and clearly had a very short time to live once they were put on ventilators, the DOC and Attorney David Apfel can give you detail after detail about what he went through with his client, Joe Mesere. He wrote a wonderful article about it. But DOC was not the least bit interested in getting his client out on medical parole until he went on a ventilator. And then they were calling his house constantly, his cell phone, his house, his work phone, to get him to agree to have his client out on medical parole so he wouldn't be a death on the DOC. I mean, they didn't say that was why. That was clearly why. So he wouldn't be a death on the DOC charts of COVID deaths. So they don't initiate medical parole on their own the way they are supposed to, the way the statute anticipates it. As Mara said, they almost never initiate a petition for medical parole. And what does happen is once someone gets out on medical parole, their parole conditions are supervised by the parole board. So the DOC makes the decision to get someone out on medical parole, but once they're out, parole takes over and supervises them. And the parole board has moved to revoke the parole of people on medical parole when they haven't died within 18 months. Because you qualify for medical parole if the doctor says you're going to die in 18 months. So we've had people be put back in prison who are very, very, very sick, but they didn't die within 18 months. So under the way our system is implemented right now, back to prison they go. So this is a really problematic process that needs a lot of help.
And because this was, the focus here is on pathways for release, I didn't give a ton of time to parole revocation, but it's a huge area of injustice, and medical parole revocation it's really rough because the statute itself indicates that it doesn't give a lot of room for due process. And I think that's something that people realized after, so the statute accomplishes a lot, but it means that people can be revoked with really minimal due process while on medical parole. And they will be revoked. There's not really the same considerations given to someone on regular parole, which we don't love those either. So, yeah.
I have one more from online, and then I'm going to send the mic around the room. But there's a question from Marlene, noting that a lot of these cases go on for a long time, that this is an emotionally taxing process, that there is a recounting of trauma narratives. And so Marlene would like to know, how can social workers support clients in managing that process from your perspective?
I don't know the best way to answer that. Does anybody have ideas of the best way for social workers? I mean, social workers are really important in helping find placements out into the community, to find a hospital or a nursing home or someplace that can provide. That's one thing that's difficult with medical parole, and one thing that why the process takes so long is because it's hard to find an approved home plan, because the person generally needs a whole lot of medical care and they often don't have much other care and support in the community, because for a lot of these folks, they've been in prison until they're, in their 70s or 80s. So they're in a tough spot to find a good placement. So social workers are invaluable in helping to find a placement.
Yeah, and not to get too much in the weeds, but there's a problem right now in the parole practice with access to social workers and other experts, because the courts are saying that only juvenile lifers have a clear right to experts for cases. So like other people seeking parole, including people with very serious disabilities, don't really have a clear path to getting help. So if there are social workers out there that are interested in volunteering, and also other experts, doctors, psychologists, there's definitely ways we can link people up to, there's networks forming of people who are willing to provide pro bono assistance to these people who could really use your help. That would be great. Thank you. There's a really exciting Medical Justice Alliance that connects medical providers with cases of incarcerated people who need assistance, and Deb is able. Yes, thank you.
Yeah.
Can I say one more thing real quick? I think it can be really helpful to have a social worker's report in front of the parole board. The parole board will read it, hopefully, and take it into consideration. So when we do try to get funds, sometimes we don't get the funds, as Mara said. So I think in my work and in everybody's work, if social workers are able to consult or provide like evaluations or referrals, that all of that would be so helpful.
I don't even know if I need the mic. Thank you. That was helpful information. I'm sorry, Patty, that the good guidelines are gone away, but who writes them? Is it the advisory board? Is it the governor's council? Like, where do they come from?
Well,
And
they're supposed to be the governor's guidelines. I doubt the governor sits down and
Right.
writes them, him or herself. But my guess is that the governor's legal staff are the people who end up writing them, and they write them with recommendations from the governor, what the governor wants in them. But the actual writers are probably the legal staff. At this point, we don't know who Mara Healy's legal staff are going to be, but I assume they'll be identified shortly after she takes office. And they usually have several lawyers in their legal office, and they each have, like, one of them handles requests for commutations, and one of them handles pardons, and one of them, they all have different tasks that they sort of specialize in. And I am assuming someone's going to be assigned the task of drafting new guidelines.
so I think the second question is, can we get a copy of those guidelines? And would the guidelines help us? We do a lot of support for parolees that are coming up. Myself and Families for Justice's handlers speak on their behalf. As a licensed clinician, I try to guide the guys and women a year out before they hit the board. I'm loving what you said, Pauline, about the wrong part of, asking them to take responsibility. We know Milton Jones just was exonerated or won his case the other day where he never took responsibility. But hadn't that happened now, if he was in front of the parole board now and not accepting that he never killed anybody, he probably wouldn't have gotten out. But would those guidelines help us understand it better and help them be able to kind of not only just take responsibility, but really the accountability part? There's key words that we try to help the young men and women with how they approach the board. Would those guidelines be helpful? And secondly, how can we as programmers or licensed clinicians be more a part of the clemency petition? Because often we just get the lawyers, we don't have a lot of Evas around, right? And so they often just ask us for a letter. We want to be more involved, more participatory in their process of this application.
I think that's the goal of this conference, is to bring people together so we all work together in a better way. in terms of looking at the current guidelines, if you, there's that Clemency 101 document, and then within it, after the summary, there's also, the guidelines are right there, the current guidelines. And then there's also a link to the Mass Bar Association report criticizing those guidelines. But we want to dump those guidelines and get some good guidelines in place instead. But it's something where we should be having subsequent conversations and figure out better ways to work together. And then I know it can be a lot of boring reading in terms of reading all these various documents, but for folks that are interested, we have provided the current guidelines, one critique of the guidelines as to how they have to change. But we do have a real opportunity, I think, with Maura Healey becoming governor to hopefully get some guidelines that are much better in place. And she's already indicated, I just saw something that she said on the news, how she was willing to grant pardons in terms of marijuana offenses that have been decriminalized. So that's it's, those are, like I said, those are not the things that, I think this audience is necessarily so excited about. But on the other hand, it's like usually no one is saying anything about clemency or pardons when they're running for governor. So I feel like we're headed in the right direction, at least.
And those guidelines, remember, those guidelines only pertain to commutation and parole. I mean, commutation and pardon. They don't pertain to parole at all, and I wouldn't even look at them if somebody's coming up for parole, because they are just about pardons and commutation. We are going to be asking the new parole board chair, who I'm actually very encouraged that she's going to change a lot of things. She's already started talking about change. Her name is Tina Hurley. She's only been chair about 2 weeks now, but she's already started moving to change things. And we're going to ask her to put out a set of guidelines for parole, because it doesn't help people to just go through the regulations and try to understand what they're looking for. But if the board put into English what they're looking for, I think it would be helpful. So we're going to ask for some guidelines for parole, just the way they now have guidelines for pardons and commutation.
Patty, is the parole board and the pardon board the same board?
Yeah, exactly, same people. Yep.
Also confusing.
I wanted to ask this group of people to, okay. I wanted to ask this group of people to put their heads together and write every incarcerated person and ask them if they want a lawyer. Whether they're disabled or whether they're over 50 or whether they've been incarcerated for 10 years or they've been incarcerated and there's the chance of life with parole, et cetera, et cetera, et cetera. But in other words, ask every incarcerated person if they need a lawyer for something, and then divvy it up amongst you who should get what.
I think Patty should get the
Just so you know, I've been working with Families for Justice's Healing, specifically as to Framingham. We have a huge incarcerated male population too, but specifically as to Framingham, looking into how we can create a screening program to have people look at every woman in Framingham and then refer them to the kind of appropriate relief. So we just started talking about this maybe a couple months ago, but we have some ideas, and I have some ideas of how to collect documents and have people review them in a systematic way that would identify people for different avenues of relief. So as to Framingham, I'm working on it. How's that?
And also, this is a conference on decarcerating women. So that's why there's that focus. I'm Mallory from Families for Justice as Healing. I think it's important to have a gender justice framework when we're talking about pathways to release And it's helpful to connect the dots that we're talking about 140 state sentenced women and then another 60 or so women incarcerated from Middlesex County, depending on the day. So I don't know how many of there are in this room, but that's literally like us talking to 2 women in Framingham. And so our goal at Families for Justice as Healing and the National Council is to do what Eva has said, and we've been talking about it for a couple of months, but we've been working on it for years. What is an exit strategy for every single incarcerated woman at MCI Framingham? And it's absolutely possible to get each and every one of those women out with an appropriate strategy and plan, with the doorways that we talked about here, and then with more that we're fighting tooth and nail to open up every day with the Massachusetts legislature, while we're also fighting against a brand new women's prison proposal, right? So that the context is the urgency of this idea that the state thinks that they need to spend $50 million for 140 state sentenced women, when we want women home in our community and we know that every day they're incarcerated, it's harmful to them. So I just wanted to say that, emphasize that is like what is possible if we are coordinating and working together in a systemic way, and that I think hopefully we can continue after today. Also, just on it would be super great if anybody's contacting the governor to make sure that formerly incarcerated women are they're given input to anything that's sent in terms of recommendations, and also get an audience with her directly. So Maura was running, we sent a memo to her, first and foremost saying, come out publicly and stand against the plan to build a new women's prison and commit to not do that during your tenure and not to allocate any funding for that from the capital budget. And then secondarily, to make clemency a meaningful part of what you do as governor in order to release women. And more recommendations under that, including to consider decriminalizing the reasons why women end up in jail and prison in the first place. So we're still trying to get that meeting. We got no response. But as you can imagine, some of us are positioned a little bit differently in terms to access to power. So another thing that we can do in collaboration with each other, and Eva is working super hard on that with us as well, is to make sure that we're connecting directly affected women to the seats of power so they can make recommendations. We can make recommendations directly. So it was super great to collaborate in the month before she's inaugurated to get these demands on her desk as a priority of all of us together. So thanks.
Hi, so I'm a clinical social worker, and I work with behavioral health justice involved currently in the community. But I worked 10 years in the state prison system with men, and I was kind of the clinician that took a lot of the first degree and second degree lifers on my case and did individual therapy. And then I created group therapy for young men's lifer groups, older men lifer groups, and then people that didn't have mental health access. I started taking a chance on change group for them. In 10 years, I helped many inmates, second degree lifers, write their parole hearings, their parole statements. And even the day I left, I had like 15 people meeting me at the HSU, but the medical unit, with like helping them with their statements, and not one ever got parole. Not one. They would always get 5-year setbacks. I think I had one person that got a 3-year setback. And it was just, they wouldn't let me do assessments. I worked in the DOC for MHM services in UMass at one point. But I just feel like this commutation, all these programs are amazing, but a lot of the second degree lifers, sometimes they were looked at, a lot of them had severe mental health issues. And a lot of them they were looked at as, their cases as maybe more of like first degree, so they wouldn't get that. So even with the commutation, then there's that's great if they got commutation to second degree, but then there's the parole board, actually giving them parole. So I just feel like that, there's so many, such a challenge with these second degree lifers who are supposed to get a chance for parole, not getting that. I mean, we're talking 25 years, 30 years, 35 years, these clients that I worked with. So I'm so glad that there's all these programs. This is great that I'm here. I'm in a different role. I'm finally getting back to justice involved work. So But I guess my question for you is like, is there any change in that? Because it's been a while since I've
Oh,
worked in the
so,
prison.
yes.
Like, I mean,
yes.
because
Absolutely, yeah.
literally, like, not in 10
Yeah.
years, not one.
Yeah, well, thankfully, I mean, the parole board is far from perfect right now. It's got a lot of problems, but we see it moving in the right direction because they have this new chairperson. It used to be all, former police officers, former prosecutors, all people from law enforcement. Right now, that's not who the board is. There's 2 forensic psychologists on it. There's a woman who's chair who's been working in parole for 35 years and believes in it like nobody else. There's some people that I'd rather not have on there, but they're not in the majority anymore. And there's 1 vacancy, and we're going to try to get Mara Healy to get a really strong advocate for clients in there as that last member. This is where it really counts to pay attention to your governor's council races and who gets nominated to be on the board, because who gets out is a result of who's sitting on the board. And who's sitting on the board? It's who the governor wants to be on the board. And so the governor has an opportunity right now to put a new board member in there. It'll say a lot as to who is going to get appointed. I'm thinking that it's too late for Baker to fill that last opening, and so it will probably go to Mara Healy to do once she takes over. At that point, we're going to have a board that's much more responsive to our clients' needs. The lifer rate for parole for second-degree lifers right now is approximately 45%. Yeah, it's about 45%, which obviously is much better than 0. Around the years 2000 to whatever, there were hardly any second-degree lifers. Then again, that happened after the Sinelli incident. There was 2 years where there were no paroles at all. But we're not in a period like that now. We're in a period where we're hoping to change the law, and we're hoping to change the parole board. And with all of the help from all of you, we're really hoping to make some real steps in getting people out of prison. And it looks like it's going in that direction right now, thankfully.
Can I add to that? Something you said that really strikes me that I think is a real challenge is that a lot of the people you were working with had serious mental illness. And something that is really hard to unravel and to address is the lack of accommodations provided through that person's experience while being incarcerated that positions them poorly to be good candidates for parole release. So a lot of this work is also about the DOC and about what accommodations, how do they identify people, what accommodations are provided. It's really hard. It's really hard for people, some people with serious disabilities, to be in the right position to be a good candidate when they get to the parole board. And so that's a societal issue and an institutional issue that we're working really hard to address, but we've seen some progress, and Patty and I think are feeling more hopeful than in many years about some people in leadership that are willing to look at these problems. So, but we can't deny that it's really hard for that group of people who are incarcerated. We're seeing releases though, and it's really cool that we now have lawyers who are specialized to really look and try to help people with disabilities to access parole like everyone else.
I'm sorry, we're gonna have to cut it off right here just because we want to make sure that we have time for lunch. But you are invited to please come up and talk to the speakers afterwards. And also we're going to have an opportunity to talk in breakout groups in smaller sessions later this afternoon. So I want to make sure all of you feel as though you have an opportunity to get your voices heard. We want to, like I said, make sure that we have time for lunch, and thank our speakers for doing presenting a range of issues. And as you heard all of them say, we could use help, right? Everybody up here said we could use help, and I think everybody in the audience said we would love to help. And so part of our goal today is to have an opportunity to create a network of people who are saying we would like to help, so that when we have an attorney volunteering for the Women's Bar Association, for example, we can pair them with a social worker who is saying, I would love to help you with this work. And so the agenda that you were given when you walk in, if you look on the back of it, it gives you an opportunity to sign up and indicate that you would like to help. So We will be collecting these throughout the day. I'm just bringing it to your attention right now because we've heard so many opportunities to volunteer and help up here, and I want to make sure that you know that there are opportunities to do that and to sign up. We ask when you fill this out to please put it, there's a box outside where you can put it in, and this will go into a database whose home is to be determined. We're working on that, but then as I said, as people are working on clemency or parole or medical parole cases, they will be given access to it. Go ahead, Norma will give us slightly more information.